520 at FM 93.5, AM 1150, WNDB. State Attorney R.J. Larizza is in studio for one of his frequent visits. Thanks for joining me today, R.J. Good to see you, sir.
Good to see you too, Mark.
The timing was perfect because the story that was in the paper today about the deputy who was texting prosecutors, were they two of your people that he was trying to help? And the news journal said they got that the deputy got counseling after that.
Well, the attorneys that I have, the two that were involved, they got an oral counseling.
Okay, they got an oral counseling.
Yes, sir.
On the surface of it, I'm thinking, if it was someone who was on the scene that had seen it, to me, it's not wrong. It's just sort of reminding them these are the facts. I'm playing devil's advocate here, and on one hand, I'm saying, okay, if justice is served by getting all the facts out, so be it. But what are the rules regarding, sideline coaching or texting in the courtroom?
Well, Mark, that's a good question. I don't know that there's any definite rules about, some situations. I mean, there's always been discussions when attorneys are in the courtroom. Sometimes it might be a bailiff. Sometimes it could be somebody who's watching. It could be one of the clerks. And they may say, hey, you did a good job, or hey, why didn't you ask that question? I mean, because there are people that come to watch trials. Now, with texting, that's different than before phones. When you didn't text, if you talked to somebody, you talked to them after, the fact, and it was more of an opinion about how things were going or what was being done. But I don't know that there are any rules about texting, between individuals in the courtroom during court. Now, jurors are one thing. They're not supposed to even have their phones typically. They're taken away from them so that they don't have any outside influences at all. So there are some rules about the jurors for sure.
We've seen, and I know I'm going by a lot of TV, where a judge will motion for counsel to approach, where they have a conversation, the mics are silent.
Right.
Could that be a period in which that kind of information could be transferred because the judge would hear it? Say, in this case, maybe it's too much to expect, but I'm thinking if this deputy who had texted the information was able to transmit this information to the prosecutor by way of the conference with the judge. In other words, could the prosecutor have said to the judge, can I approach? I've got this information, and that way it'd be in full witness of the judge. Could that happen?
I suppose that scenario is possible. Yes, sir.
Yeah, because I'm just trying to think. We have so many challenges now that we didn't have before. Is it getting harder in jury trials to get people who are honest brokers in this, that haven't been influenced by the headlines, the radio, the television, or something else?
You're talking about the jurors, basically? Yeah. It depends. Some cases, are covered so heavily that it's hard to find folks that haven't heard about it. But even if they've heard about it, Mark, that doesn't mean that they're going to be incapable of being fair and impartial. So they're questioned about their ability if they've heard things. What did they hear? Are they willing to set aside what they've heard? Now, if they hear something that might be inadmissible in court, or some opinion or about something that happened that may not necessarily be true or be debatable or speculative, then that's more difficult to try and say, could you put that out of your mind? But I think that jurors truly try to be, fair and impartial. They want to be. And I think that most of them are honest when you ask them during your jury selection if they can be.
During your administration, you've had several high-profile cases, including those on sentencing. Is there a sort of a criteria or a book that you go by as the chief law enforcement prosecutor here that, let's ask for a change of venue because it's going to be hard for us to get what we want?
Rare. I think most of the time it comes from the defense attorneys, and it's really that primarily their job is to advocate for their clients and to protect their clients and make sure that they do everything they can to ensure that a jury is fair and impartial. And, of course, so is the state. We want a jury to be fair and impartial as well. But typically you see those motions coming from defense attorneys more. If the state's asking for it, I'm speculating a little bit, but I think most of the time both sides agree. And we say, okay, let's find somewhere else.
You have a conference coming up, some kind of a state attorney's conference. Can you tell us about that?
Yeah, it's coming up, I think the 20th or 21st of this month. It's going to be down in Naples, Florida. All 20 circuits or all 20 state attorneys typically will be there. We're going to recognize several legislators who helped us this session. One of our local legislators, Representative Paul Renner, who represents, I think, out of the Flagler area, who's going to be Speaker of the House.
That's right.
In a few years, I think 2023 maybe. But he's being recognized for a leadership award. I worked very closely with him during the session. He was very helpful. He asked good questions. He's very vigilant. The president of the Senate, Senator Galvano, is going to be there. Senator Bradley, who was chair of the big appropriations chair, is receiving an award. He's going to be there. So we've got several folks that are coming we're going to recognize, and we're going to talk about the new legislation and some other issues that affect all of the state attorneys and the people of the state of Florida.
There's going to be a census done over the next year. Is that likely to reshape the circuit for you?
Well, it's interesting you bring that up. We recently discussed some questions from a group called OPAGA. That's, I think, the acronym for the group. It's a state organization that basically educates and informs the legislature about certain issues, and they're looking at the circuits to kind of the workload, the boundaries. Circuits are drawn by county. For example, the 7th Circuit's 4 counties. The 11th Circuit, which is the Miami area, is 1 county. Then you have Bill Cervone's circuit, the 8th Circuit, which Gainesville is the county seat or the headquarters, but there are 6 counties because they're more rural and less population. So I think there's some questions about should the circuits be looked at, should they be modified or amended maybe. I don't think that's necessary, and I think that's a consensus of the Florida Prosecuting Attorneys Association, and we'll share that with the legislature.
Because if I'm not mistaken, your circuit, which is the 7th, is larger than congressional districts.
It's larger than the congressional district, and it's larger than several of them, I think, throughout the state of Florida. It's geographically, it's large. Population-wise, it's about middle of the road. I think about 1 million folks are close to it or reside in the 7th Circuit.
So to circle back to the question of getting a fair trial and getting a fair prosecution, if in fact a crime transpires in the very bottom of the district where it may be heavily publicized, is it possible that you can try the case in the northern part of your circuit to avoid that extra press?
Absolutely. We did that with, it was done with the Victorino Hunter case, and there were a couple other co-defendants as well, was tried in St. Johns County. And there was another case, I think recently, I think it was called the Dollar General. It involved the Dollar General. I believe that was also tried in St. Johns County. So, yes, you can see there's 2 media markets in the 7th Circuit. There's the Orlando market, which covers, basically Daytona or Volusia County.
Then you get Jacksonville.
And then you've got the Jacksonville market, which covers Putnam, Flagler, and St. John. So you have... The good news about that is sometimes something that happens in Volusia County may not necessarily cross over into the Jacksonville market. Therefore, those folks just haven't seen it.
There's been a lot of discussion about the death penalty, the changes slowly being made in this. Are you concerned as a prosecutor that if they make wholesale changes, eradicate the death penalty, that we're going to have retry people?
Well,
anybody who's on death row, would they have to be retried?
Well, that's a good question, because right now the Florida Supreme Court is considering, they made the changes to the the law retroactive to a certain point. The Hearst decision. Now they're talking, the Florida Supreme Court is going to take another look at that. In other words, they could come back and say, no, that is, you shouldn't apply it retroactively, only prospectively. And Mark, what happened when the changes first came about was the legislature tried to pass a law that said that everybody on death row, everyone, was entitled to a new penalty phase because of the Hearst decision. That didn't make it anywhere, and the Florida Supreme Court, what they did is ruled that anybody that was sentenced to death after the Ring v. Arizona decision, which is really the seminal case that actually created the Hearst decision, which was in, I think, October of 2002, right, or maybe 2001, right around in there. They drew the line in the sand there, said anything after that, you have to retry the penalty phase. Anything before that, you don't. So, I mean, that's always an open question, and it's very perceptive of you to pick up on that.
Well, the thing I'm getting at, too, RJ, is if they go back too far, many of the people who testified in the original trial, either that or the sentencing phase, may have deceased.
That's right.
Or you can't find them.
No,
and then what do you
right
do?
Too. Well, you can always use former testimony, which, but that's not the same. I mean, no. Mark, you basically have somebody sit in the witness chair, and you have the prosecutor ask the direct questions, and that witness, so to speak, that's sitting in for the witness who's no longer available will answer the questions. But it's just not the same as having that person there that saw and heard and experienced what they're testifying about. Sometimes you can do that. Sometimes you might come up with other witnesses that didn't have former testimony that are now no longer available. So it's very difficult. But don't forget the families, Mark.
Yeah.
I mean, can you imagine? I mean, how tough it is when we talk to the families for Victorino and Hunter to try to explain to them. One, they don't want to hear it, and I don't blame them. Yeah. Two, it just opens all that up all over again. And, I mean, how cruel is that? Now, I understand defendants have a right that they have a right to the benefit if the law changes, if we're a country of laws, we're a state of laws. And I get that. But, let's don't forget what this does to the families who have to go through that all over again, too.
We're talking with R.J. Larizza. He's the state attorney for the 7th Judicial Circuit. And I remind our listeners, this is an unrehearsed interview. There are no questions that are given. There's no scripts, nothing. Just the two of us speaking. And I want to give you an opportunity at bragging rights for some of your stars in the circuit, knowing that you're very conscious to not leave anybody out. Some bragging rights, I want to give you an opportunity to talk about any of the people who have made some good cases in the circuit.
Well, I can tell you we have a great team. And I'd like to, I think, first to acknowledge John Reed and Spencer Hathaway, which are here with me right now. They were excellent trial attorneys, some of the best we've had, but they sacrificed that to come on board as supervisors to make sure and train and mentor the youngsters that we have now. I mean, we've got folks like Ashley Terwilliger and Andy Urbanik and Mary Catherine Kroc, and we have Samantha Zaleski and Kevin Sullivan, who are career criminal prosecutors that handle the child molestations, the sexual batteries. They handle the carjackings, the armed robberies, the attempted murders. We have, Tammy Jacks and Ryan Will, and we have Heather Tragonas, and we have Mark Johnson and Jenny Dunton, who are homicide prosecutors due to all the homicide cases. I mean, our managing attorneys, I could go on and on. I'm very proud of the people we have.
There was one name that just jumped out at me, Mary Catherine Kroc. Wasn't she the daughter of a prominent attorney?
She's the daughter of yes, she is.
James Kroc.
Yeah, she sure is. And in fact, when I swore her in, her mom and dad showed up, and just a lovely couple, and how proud they must be of their daughter. I mean, she's, Mary Catherine's got special skills and talents like so many others that I mentioned and more. I don't want any of the other folks to feel like, I'm forgetting about them. We have 85 lawyers.
I know. And
85.
Nora Hall is with you too, correct?
Nora Hall's with the Attorney General's office.
Oh, that's right. But did she do a time with your office?
Not since I've been state attorney.
I think she was a public defender.
May have been. I don't know.
Now she's with the Attorney General. I lose track. Sir. You've also had several prominent people become judges.
Yes.
And there was a time where you were losing them pretty quickly.
Yes, we've lost quite a few. Some of them, and of course, you're happy for the folks that succeed up and rise to the level of a county or circuit court judge. But yeah, we've lost maybe around 14 folks since I got elected are now judges.
Well, I remember when Leah Cates stepped up.
Right.
And, Karen Foxman's now a
That's
judge with her husband
Matt.
and brother-in-law. They're also on the bench.
Right.
When you have cases, and this is a question, Mr. State Attorney, I've asked you in the past. When you have cases that are going to come before a judge who served in the department, do they automatically recuse themselves? Or how do you handle that?
You mean if we have a parent or a judge who's related to the prosecutor?
Yeah.
Typically they will. Yes.
Okay. What if, like in the case of Judge Cates, who worked a lot of different assignments while she was working for you, is there a possibility that through that system somebody could come up and face her that she had worked in the state attorney's office handling something that involved that person at another time?
Sure.
Would
It's
she have to
possible.
take herself out?
It's really up to the judge to decide, or sometimes the defendant will file a motion to disqualify a judge. But a lot of times the judges do that on their own if they don't feel comfortable because of a relationship they have. So there's two ways to do it. The judge can do it voluntarily without being asked if they feel it's appropriate, or the defendant can do a motion to disqualify.
I've been in the courtroom watching some cases recently, and I'm curious that when people make first appearances, do you have the same people work all the first appearances, like for the day, or how does that work? Or they're assigned to an individual case as the prosecutor?
During the week, Monday through Friday, we have a full-time attorney. It's Dustin Havens. He does all the first appearances Monday through Friday. On the weekends, we have a rotating basis, and we have attorneys, all the other attorneys sign up and have their time, so to speak, doing first appearances on weekends and holidays.
Okay. Do they do this on Sunday? Or Sunday?
Oh, yes. Oh, yes.
Really?
And every day. There's no exceptions. It's kind of like what's open 24/7, 365. Walgreens, or you always go there on Christmas Day to get batteries or whatever. But no, Florida requires a first appearance within 24 hours of arrest. So that means every day. And so sometimes when you have the big holidays, Thanksgiving, which is a 4-day holiday, Christmas, others, you'll see the emails fly and can you cover this, or would you be, because somebody has to be there to do them. Now we are working to do video. I think in St. Johns County we're setting it up, and we do it
video first appearances.
Video first appearances. I think we're doing it in Flagler, and I think Putnam and Volusia. I think we're working on it there too. I don't think it's happened yet, but at least you can do it from your home instead of going out to the jail.
Really?
Yes.
So in theory, a person could make a first appearance from their home if they have like Skype?
Well, not the defendant, not the person arrested, but the judge and the prosecutor and the public defender, and I guess even a private attorney. But all the private attorneys might not have the same setup. They wouldn't have the setup we would have to be able to do that.
The person making the first appearance presumably would be incarcerated.
Yes, they'll be locked up in the jail. So you got your cameras or whatever system at the jail. You have it set up. They're in the room. They bring them in, but the judge, the prosecutor, and the public defender are all remotely accessing through the camera system, Zoom, whatever scenario we've got set up, and can conduct it. I mean, there's no reason you have to be physically there, so long as you're able to review all the documents and able to review the actual courtroom.
Let me a memory question here, if I can test you a little bit. From when you first came in office, there were some cuts made to the funding for state attorneys. Your
Right.
predecessor had 7 cuts made in his final years before you took over the reins. How has the legislature been to the state attorneys in general in terms of funding?
Well, I can tell you I'm proud of the last 2 years. I'm just stepping down as president of the Florida Prosecuting Attorneys Association. I did 2 years in that role, and both years we got some money from the legislature. This year it was a landmark. One of the things that I think I'm very proud of, and of course I can't take all the credit, but I'd like to think that all of my colleagues and I together, we were able to get the legislature to raise the minimum salary for prosecutors and public defenders from $40,000 a year to $50,000.
Wow.
So that's still not as competitive as some. You're probably looking in private practice with a decent law school career of 60s to 70, 75.
Yeah.
Of course, the elite up more towards 100,000. But making it $50K as a starting salary is something. It's a big help.
Yeah, and not to make people feel worse, but boy, that salary range, most people, including me, did not know that. And I'm thinking they've got student loans to pay off.
Oh.
They're trying to raise a family, and they're doing $50K. How do you hold them?
No, and plus not only that, like I mentioned, John Reed and Spencer Hathaway and several others, they've got kids.
Yeah.
I mean, they're starting. These young folks are starting their professional career and their families all at the same time. No, I mean, it's not unusual for folks to have over $1,000 a month that they're paying in student loans, and that's before you factor in rent or mortgage payments, car payments, groceries, you name it.
We're going to take a break, and then we'll continue our one-on-one discussion with R.J. Larizza, the state attorney, in just a moment.